Hi there, this is Jonathan Ginsberg, and I'd like to talk to you today about some of the feedback I'm getting from Social Security judges in the cases that I'm trying, and specifically about some of the weaknesses that these judges are seeing in cases and just what you should be aware of when you go into a hearing. And specifically what I'm talking about is that I've had several judges tell me that they're seeing a pattern over and over, and that pattern really involves cases where you have claimants who walk into the hearing room and they appear to be clearly disabled. I'll give an example. I had a case recently where my client is well over 350 pounds. She had a knee replacement. She is not doing very well. She can't walk without a cane. She has a terrible limp. She's in obvious pain. She testified that her doctor wants her to keep her leg extended during the course of the day, leg raised, and that she really is in a recliner most of the day. And in this particular case, the judge acknowledged that he believed her, that he really thought that she had not had a good result from her knee replacement surgery and that she was really in a lot of pain. The problem is, as the judge pointed out to me, there was just no medical evidence that my client had gone to the surgeon about a year previous to prior to the hearing, and the surgeon had seen her a couple of times afterwards, basically said she was doing well, and she acknowledged that for a couple of months she was doing well, but that after about 3 months she started experiencing a great deal of pain and limitation of movement, and started having to use a cane, and then developed this terrible limp, and then developed kind of this chronic pain syndrome. But she can't afford to go to the doctor, so she's not been able to go to the doctor. She doesn't really have much follow-up. So what the judge is looking at is a medical report from the surgeon saying that the surgery was successful and the knee replacement was successful, there was no infection, that the claimant was feeling a lot better, and then it stops. And the next thing we've got is a year later, a report from a family doctor saying that she needs pain medication, but really no functional evaluation. And so the judge and I even chatted about it after the hearing, and he said, look, I acknowledge that your client's in a lot of pain. I have no doubt that she would have a really hard time working. I have nothing to base it on, nothing at all. He even went so far, and this judge really went out of his way, he went so far as to order a consultative evaluation, but we both know, he and I both know, that an orthopedic evaluation from a consultative doctor at an industrial clinic someplace is probably not going to result in a report that would be sufficient enough for him to approve this case. So essentially what he was saying to me, he wouldn't come out and say it, but this is really between the lines, is I believe your client's probably disabled. There's really no medical evidence. I'll go through the motions of getting a consultative report, but you and I both know that consultative report's probably not going to give you what you need, but it will allow me to deny the case based on lack of medical. And not that I want to deny it, but I've got to do something with it, and I can't approve it. Because in the climate nowadays, if I try to approve a case without medical evidence, I'm going to get reversed and I may lose my job. So that's the issue. And during the course of this representation, my client had told me at one point that she had talked to her doctor, her family doctor, about getting a functional capacity evaluation. The family doctor says, I don't do that, but here's a place you can go. And she called up, and it turns out it was going to be $300. So I said to them, look, said to my client after the hearing, look, you can spend $300 and get the functional capacity form filled out. If it's helpful, that's going to go a long way to getting you approved. If it comes back it's not helpful, doesn't support you, you're going to lose and you're going to be out $300. If you don't get it, you have almost no chance. So my point here is simply this, that if you are applying for disability and you cannot afford to go to the doctor because you don't have any insurance or you don't have any money, I understand that. It's a big problem. But you're not going to win Social Security disability if you don't have medical reports that support your assertions of disability and that identify specific functional activity limitations, activities in sitting, standing, walking, getting through the day without extensive pain, maintaining attention and concentration, all these different things that appear in a functional capacity form. So one way or the other, you're going to have to get these medical records, and it's not an easy problem to solve, but if you don't have them, I can tell you with almost certainty you're not going to win. So these are some of the issues that judges are seeing, and I think that the way the judges have resolved it is basically saying, as much as we'd like to approve somebody based on what they appear to be, we're just not able to do that, and you're going to have to either provide us medical evidence or we're not going to approve your case. So that's kind of what's going on out there. I wish I had better news for you, but and I realize there's not a lot of low-cost medical sources, but if you have the time, and if you have a year and a half before your case is coming for a hearing, I would tell you, find a way to get to the doctor, find a way to get a functional capacity form. But that's really the only hope you've got at getting approved, unless your doctor is really willing to go out on a limb for you and not charge you for that. So again, that's what I'm saying. Hope this has been helpful. And this is Jonathan Ginsberg. Until next time, we will talk to you soon.